for the government of Saskatchewan. Saskatchewan intervened in these proceedings for two reasons. First, because of concerns that the measures taken were overbroad in two senses. First, that they interfered with provincial powers, and second, that they infringed on the rights of citizens. Second, because of concerns that the statutory threshold for invoking a public order emergency was not met. First, Saskatchewan is very concerned about the impacts of invoking the Emergencies Act on federalism. The Emergencies power flows out of the Peace, Order, and Good Government Clause in the Constitution Act 1867 and gives the federal government the power to temporarily assume provincial powers under the Constitution. In many ways, it is like the notwithstanding clause in the Charter. In this case, while the federal government has said that it was simply providing additional tools to police, the fact is that they assumed significant provincial powers. Policing is a matter that falls under provincial jurisdiction. The Emergency Economic Measures Order is not just about banking. It expressly deals with credit unions, insurance companies, trust companies, loan companies, securities dealers, and investment advisors, all matters that fall under exclusive provincial jurisdiction. While many of these powers were not relied upon by the police, the order itself caused confusion and represented a serious and, in our view, unnecessary intrusion into matters under provincial jurisdiction. Second, the province is also concerned that the measures adopted under the Emergency Economic Measures Order were overbroad and may have infringed on the charter rights of Canadian citizens. But we will leave the submissions on that point to the Civil Liberties Group. Next, I'll turn to the threshold in the Act. Again, there are two branches to Saskatchewan's argument. First, the threshold is a statutory test. It's a high threshold, and it's a high threshold for a very good reason. The threshold is not whether the Emergencies Act was necessary or whether it was helpful. The test is whether there are reasonable grounds to believe that a public order emergency exists. Others will discuss, I suspect in great detail, whether that threshold is limited to threats to the security of Canada as defined by the CSIS Act, or whether it's broader. I'll largely leave those arguments to others. However, there is one point that we think you must keep in mind as you sift through the evidence, and that's Section 3 of the Emergencies Act. Section 3 provides that a national emergency is something that exceeds the capacity or authority of a province to deal with, and specifically provides that a national emergency can only be invoked if the situation is such that it cannot be effectively dealt with under any other law. So you will need to examine the tools that were available to law enforcement to deal with the protests. We've heard a lot of evidence about tools in this case, and I would say that the Emergencies Act and tools is a bit of a chicken and game problem. Does the emergency arise first and then the Act provides for tools to deal with the emergency? Or can an emergency arise because there aren't sufficient tools to deal with the situation? I tend to think it's the former, and I think there is a concern that the Emergencies Act should not be used simply as a way to fill in the gaps in the law. That was never its purpose. Second, Saskatchewan's primary focus in this case is on the consultations with the provinces. It is Saskatchewan's position that the consultations in this case were inadequate. We say that there are a number of things you should focus on. First, the precedent from 2020. Second, there were opportunities to consult with the provinces earlier. We've heard that the Emergencies Act was on the table by February 9th or 10th, if not earlier. The federal government could have consulted with the provinces at the front end instead of at the back end. Third, there's evidence which we will suggest shows that the decision to invoke the Emergencies Act was de facto made on February 13th before the First Minister's meeting. The Prime Minister confirmed this morning that the consensus at both the IRG meeting and the Cabinet meeting on February 13th were to proceed with the Emergencies Act. Fourth, the actual meeting that was held with premiers on the 14th. This meeting was set up on very short notice with no indication of what the subject matter was to be, and it lasted about 1 hour. When we file our written submissions, we will refer you to case law in other contexts, which suggests that this is not an adequate consultation. Commissioner, those are our submissions on the key points that you need to consider during your consideration of the evidence that you've heard over the past 6 weeks. And finally, in closing, Commissioner, on behalf of Mr. Morris and myself, we would like to thank you for providing us with the opportunity to participate in these hearings virtually. It was much appreciated. Thank you.